My name is Liz Pfeuffer. I'm Family Court Commissioner in Kenosha County. I'm in my 8th year there. I'm in my 26th year as an attorney. In my work career, I have been a district attorney assigned to the drug unit in Denver, Colorado before marijuana was legalized. I've also been a full-time college professor, and I've practiced many different types of law. So today I'm presenting on THC and FCC, Family Court Commissioners, tips, tricks, and takeaways to get attorneys, paralegals, anybody ready to come to court and talk about these issues.
Okay.
Recent changes have really impacted family court cases. We have seen such an increase in parents using marijuana. I'm in Kenosha County, which is a border county. Illinois is our neighbor, and when they legalized marijuana for all uses, I saw a great increase in parents accusing other parents of using marijuana, and other parents just admitting it, forgetting that it is a federal felony, forgetting that it's illegal in Wisconsin. So I've seen a large increase in my cases, and I know other commissioners have as well. I find that there's willful ignorance. I don't think people are confused. I think they absolutely know it's illegal in Wisconsin. But because in Illinois it's legal, they just bring it over. There definitely can be legal consequences depending on the use and the effect it's going to have on the children that are placed with them. First of all, for custodial decision making, you have to have a clear mind. You have to be responsive and actively parenting your children. That may not happen to someone who is perhaps abusing marijuana. In addition, placement. We need to make sure that children have safe, stable environments. Exposure to marijuana isn't necessarily an unsafe or unstable environment. It just depends on a lot of circumstances. In Wisconsin, it is illegal, so there shouldn't be any exposure to marijuana in the state of Wisconsin. We don't want parents demonstrating and normalizing criminal behavior in our state. It's trickier when the parents live out of state, and we are surrounded by states where it's legal. When the parent lives in a state where it's legal, then the shift in focus becomes on whether or not they are modeling responsible behavior, because it's not criminal in their state. Although, and this is a more conservative viewpoint, it is still a federal felony. It is still a Schedule I substance. So even though their states have legalized it, aren't prosecuting them, they're still committing a crime technically. There's a lot attorneys can do to prepare their judicial official for their case. Education is definitely needed for a lot of judicial officials. No offense to them. There's a lot of antiquated views, there's a lot of misinformation, and a lot of people base their knowledge on what they knew from when they were growing up. This is not the same marijuana that we're talking about now than in the 60s, 70s, 80s, and 90s. In terms of potency, availability, use, access for children, and the effects of marijuana. Many people have the impression that it's just marijuana, that it doesn't cause problems. It's not as bad as alcohol. It's nowhere near heroin or meth. But research is increasingly showing that there are problems associated, especially with the higher potency THC that is available and unfortunately readily available to some children. We need attorneys who are going to come in with information that they can provide. Affidavits ahead of time are always helpful when you're preparing your case as a judicial official. Educating them on the risks, the exposure, the problems associated with it can absolutely help the judicial officials. They have a lot on their plate. They have a lot of cases, they have a lot of nuanced things that they have to figure out. Attorneys can make it easier for them by giving them facts, information, and helping educate them without it feeling like they're lecturing. Judicial officials generally don't like to be lectured to, but we are open to receiving the information. So there is a way to present that for the attorneys that I think will be very beneficial to their cases. We see allegations of marijuana use without substantiation all of the time. They need to be able to back up conclusion with facts. An easy way to do that is drug testing. Drug testing is a great way to determine if someone's been using marijuana. Typically what I find is the person accused will offer a UA, which is not the most reliable, and also it only tests for recency of use. My favorite is the fingernail test. That goes back 4 to 6 months. It's going to find marijuana, it's going to find any drugs they're using, as well as a hair follicle is my second favorite. What I have also found is when the parent suspects marijuana use, they don't really have the concrete facts, but we're in court and the cards are on the table, and when I'm letting parties know that I can order a drug test, it is amazing how all of a sudden people remember that they have actually used marijuana or exposed to it, and they come clean, and then we don't even need the drug test. Lots of steps lawyers can take, and it's actually so easy. This is such a hot topic. I'm not just saying that because I'm presenting on it, but it is all over the news. It's everywhere. It's on TikTok, Facebook. You almost can't get away from this topic. The legalization in the states, we are up to 40 states where it is legalized for one purpose or another. We are in the 10 that have held strong and held out for whatever reason, but it is all over the news. You're constantly hearing stories. So that makes it very easy. Google is your friend. Before I did this presentation, I kept Googling, kept counting the states. I have a chart where I'm adding to it, a spreadsheet where they've changed, because the last time I gave something similar in this presentation, we only had 38 states where there was legalization, so you have to stay on top of it. Also, on the federal level, there is a lot of buzz right now because the administration is recommending changing this from a Schedule 1 on the Controlled Substances Act to Schedule 3, which is a huge jump. Schedule 1, you cannot get a prescription, there's no medical use, those are the untouchables. Schedule 3, there are recognized medical uses and you can get prescriptions for it. So that is the big deal in Washington, D.C. right now. Going to seminars is an excellent way to stay on top of it. Researching, finding the news, and being on your listserv is also super helpful too. Biggest piece of advice I can give you: know your facts. Don't just come to court and say, this person uses marijuana and we want sole custody primary placement. Don't come to court and say they have a marijuana problem. You need to articulate why you're reaching that conclusion. I don't know if this person has a medical card and is using a gummy to help them sleep or with nausea, versus they're using it daily, recreational, they've lost their job, etc. Something in between. You have to come with more details than just it's marijuana, because it doesn't have the impact that you might think it does because of the 40 states that legalized it, the fact that so many people are using it. Fun fact is more people in the United States admit to using marijuana on a daily basis now than alcohol. So it is important when you tell me someone's using marijuana, you give me a lot more details. How old are the children? How is it impacting the household? What effects is it having on this person's ability to parent? It's not enough anymore just to say marijuana.